Hi everyone, happy Friday. I'm so glad you can join us today for a webinar about Baker and Marchman Acts. We are fortunate to have with us Samantha Vacciana. She is the FLS Board President, so thank you so much for your support and dedication to FLS. And I am going to launch a quick poll while I'm reading her wonderful bio here to see who's in the audience. So we've got a poll that says what best describes your role? And then there's a second question below. Do you have any experience with Baker and Marchman Act proceedings? So I'm going to go ahead and launch that poll so you can get that poll filled out while I am doing the introduction here. So Ms. Vacciana is a fierce advocate for her clients in the courtroom and within the community. She attended Florida Atlantic University, where she earned her bachelor's and master's degrees, and she graduated cum laude from the University of Florida with her JD. Go Gators! I had to put that in there. From there, she was awarded the prestigious Equal Justice Works Fellowship. In conjunction with the Legal Aid Society of Palm Beach County, she developed a program that assisted immigrant victims of domestic violence. After her tenure at Legal Aid, Ms. Vacciana worked for the Office of Regional Counsel, where she represented clients in misdemeanor, juvenile, mental health, and serious felony cases. In 2012, she proudly opened the doors to her own law firm, Trial Lawyers of Florida. The firm skillfully advocates for clients in criminal defense and personal injury law. As an immigrant from the UK with Jamaican roots, her background fuels the dedication she has to her diverse community. This passion has led her to serving in several leadership positions and nonprofits, such as with Florida Legal Services, Florida Association of Criminal Defense Lawyers, the Florida Bar Foundation, the Florida Bar Grievance Committee, Caribbean America's Soccer Association, and Gang Alternatives Project Renew. And somehow in between doing all this, she has time to do a webinar for us. So I really appreciate you being here today. And I'm gonna go ahead and end the polling. It looks like most people voted, and let's see what our results are. So we have an overwhelming amount of legal aid and legal services attorneys as expected, a couple pro bono attorneys, and other. Sorry, I must have forgotten a category there. And only one person has a great deal of experience with Baker and Marchman Act hearings. And then let me see, limited experience, 27%, 67% no, I've heard of these proceedings but have never represented anyone, and then 4% said I have no idea what Baker Marchman Acts are. So we've got a good variety with us today. I'm so glad you could join us, and thank you again, Ms. Vacciana, for your service on our board and for doing this webinar for us.
Thank you so much, Christy, and thank you guys for having me. Welcome, everyone. One thing I am excited about, I feel like I'm home with the Legal Aid crew because Legal Aid is where I started my career, one of the best jobs I ever had in my entire life, even before law school and after law school. And so I feel like I'm back home. So it's good to see everybody. I'm going to close this poll out. So I'm glad also that there is a mix of those who have experience or limited experience, some who have no idea what Baker Act, Marchman Act is, and others who have a lot of experience. Or I think there was one or two persons that have a lot of experience. So I'm pretty excited about that. So let's jump right into it. As Christy said, I am a private attorney with the Trial Lawyers of Florida. I spent 6 or 7 years working for the Office of Regional Counsel and really developed most of my Marchman Act and Baker Act experience there. And now I also do Marchman Acts and Baker Acts in my practice area. All right, so let's look at some mental health stats. Some of you are probably very familiar with some of these statistics. So 5% of adults experience a mental illness in any one year. That's equivalent to 43.8 million people. Almost half the adults in the US will experience mental illness during their lifetime. And the part that I found alarming when I was working at regional council and even now in my private practice is that people with mental illnesses are arrested and sent to prison in disproportionate numbers. And I've seen people who are charged with a felony because they walk into Walgreens and they point a firearm at someone because they are having a mental break and they believe that this person has done something to them or what have you, and they end up in the Department of Corrections. And the sad thing is, in Florida, there really is no in-between. When you're talking about criminality and mental illness, it's either you get outpatient treatment or you end up in DOC. It's very, very disheartening. But there is some help in the sense of Baker Acts and Marchman Acts. So let's talk about that. So Baker Act or Marchman Act, what's the difference? That's the question, what's the difference? So while the two are often spoken about interchangeably by laypersons, both statutes are very distinct in how they operate and they are very distinct in the final results. They are completely different, but a lot of people will say, oh, I'm calling to have my relative Marchman acted, or I'm calling to have my relative Baker acted, and they think they're talking about the same thing, and more often than not, they're completely the opposite. So let's start first with the Baker Act. The Baker Act is governed by Florida Statute 394, and it's the law that allows police, doctors, or mental health professionals to have someone committed, excuse me, for an involuntary 72-hour mental health examination. This is important to know because if you have a client who comes in and for some reason you think that this person may need to be Baker acted, you can't just call the state mental health facility, the state hospital, and say, I have someone, can you come Baker act them? There's only certain people that can effectuate or enact a Baker Act, and that is the police, and that's oftentimes why people also end up getting arrested because they're doing something that deviates from the norm, and then the police are called, and the police, realize that there is a mental health issue, and they'll have them Baker acted, but oftentimes too, they're also charged with a crime at the same time. So it's limited. The statute limits only police or law enforcement, doctors. So you could call your loved one's doctor and say, listen, my loved one is having an issue. Could you have him or her Baker acted? That could happen. Or mental health professionals. Sometimes people go to see a therapist, and based on what they say or their behavior, they're Baker acted. Both children and adults can be Baker acted. So the criteria to Baker act someone, he or she must meet the following criteria based on the statute. There has to be a reason to believe that he or she is mentally ill. Acting strange or acting weird, as people may say, that's not enough. This means that the impairment of the mental or emotional processes of that person that allows them to understand and perceive reality has to be a defect, if you will. There has to be some kind of impairment of that, their ability to understand and process reality. Because of his or her mental illness, the person has refused to be voluntarily examined, or they're unable to determine whether examination is necessary. And without treatment, the person will cause serious bodily harm to himself or to others in the near future, as evidenced by recent behavior. And I just want to look at this element or this part of the statute. Without care or treatment, the person will cause serious bodily harm to themselves or others in the near future, as evidenced by recent behavior. So a case I just had recently, there was a young lady in the front of her mother's house, cutting down all of the trees with some kind of sharp object, or trying to cut the trees with some kind of sharp object. And the neighbor came out and said, "What are you doing?" And the young lady said, "These trees are demonic. They've been trying to encourage me to do these bad things. They're demonic. I'm cutting them down." So her mom called the police and she was Baker acted. That's an example of recent behavior. And this person also has a history of schizophrenia and bipolar, but without care or treatment, she's threatening the neighbor with a pair of shears or some other sharp object. She's threatening to harm the neighbor, so that's the serious bodily harm to someone in the near future. And then it's evidenced by recent behavior, the behavior of the trees are demonic. They're talking to me. I feel like they're taking over my life and that kind of thing. So that part of the statute is important because even just because someone has a mental illness, and this is a lot of times what I tell the parents of my clients, just because this person may have a mental illness, if they're not doing anything in the immediate present that that shows that they're about to harm themselves or others, the Baker Act is not going to apply. All right, so conversely then, who cannot be Baker acted? People who are intellectually disabled cannot be Baker acted. If they are developmentally disabled, they cannot be Baker acted. Now, that's to say they cannot be Baker acted because they are developmentally disabled or intellectually disabled. If they're exhibiting behavior, though, that shows harm to themselves or others, as evidenced by recent behavior, which we just spoke about, then yes, they can still be Baker acted. But just because someone's intellectually disabled or developmentally disabled, you can't Baker act them. And someone who's intoxicated or substance abuse impaired, and their behavior is based on the intoxication or substance abuse impairment, they cannot be Baker acted. All right, we talked about earlier about who can invoke the Baker Act statute. It can only be done, as we said earlier, by law enforcement, physicians, mental health professionals, or judges. Family members, friends, etc. can't invoke the Baker Act. Instead, they have to involve law enforcement if someone is experiencing a mental break or contact his or her doctor. The other thing that the family members can do, and you as legal aid professionals can do, is you can request an ex parte order from the judge. And as most of you probably know, there are very few things that we as lawyers can do ex parte. This is one of those things that if you have a client who you believe is a danger to him or herself or to others, as evidenced by their recent behavior, then you could file a petition with the court ex parte and request that this person be Baker acted, and then there'd be a hearing held on it and whatnot. And the good thing is too, because this is a removal of one's liberty, the court would appoint the public defender to represent the person that you're trying to Baker act, so that their rights are protected. We're not just Baker acting them because they're a little inconvenient for us or we don't like the way they function or whatever.
We had a question.
Yes, ma'am. Go ahead.
I
I'm sorry.
think it's perfect spot to address this. Do you know of statistics concerning systemic racism in Baker Acts and Marchman Acts?
As we talked about a little bit yesterday, Christy, I don't know, to be honest, the ethnic breakdown on people who are Baker acted or not. I can tell you that in my practice, both when I was at regional council and and in my private practice now, I see a mixture of different people. I see veterans, I see Black people, I see white people, I see, people of all races, and I don't necessarily see one or the other. Now, I will say this, though, in all candor, that when it's a criminal type Baker Act, that tends to be a little bit more, you'll see more minorities. And when it's Baker Act from people who are homeless, you'll tend to see a little bit more minorities. But to be frank, I think this is a situation where it's across the board. I don't personally, from my experience, but statistically, I don't know what the answer is to that question, to be honest.
Okay,
I hope
great.
that that answered what was asked.
Law enforcement had to be involved. It made me wonder, and then I saw that question pop up from an audience member, and I thought it was perfect timing. I wonder if people might hesitate to call law enforcement on their loved ones.
Now that, yes. Oh, that's the question. Okay, I'm sorry, I misunderstood. Yes, I think that is absolutely true. Again, I don't have statistical or empirical data, but I will tell you that as a general rule, even in the environment or the culture that we're in right now, if you believe that your loved one may be shot because they are of color, you're going to be hesitant. And as a matter of fact, I believe there was a case a couple of years ago where the mom called the police on her son and he was shot and killed. I don't remember the exact name, but so I do believe that, and from that perspective, ethnicity is going to have a lot to do with it. I think that people of color, and again, especially now, are going to be hesitant to call the police if their loved one is, a danger to themselves or a danger to others. And quite frankly, I think I would, even as a lawyer knowing better, I would probably think twice if I had to call the police because one of my children or loved one was, having a mental breakdown.
That makes sense. I'll put a link in the chat to a report by the African American Policy Forum. They're the ones who came up with the Say Her Name campaign. And I thought there was one woman who had been killed by a police during a mental health check, but they have two listed on here, so I'll link to that. We do have one more quick question. If a child has ASD, which I think is autism spectrum disorder, and is meltdown due to the autism, if he or she is harming his or herself, can they still be Baker acted?
Absolutely, absolutely. Because remember what the statute said, it's the threat of or actual causing harm right now, evidenced by behavior right now, that you're going to cause some harm to yourself or someone in the future. So even though that person is autistic, yes, they could be, kind of what we were talking about before when we said, even if they're developmentally disabled and there's something that they're causing a danger, because this statute really is designed to protect you from harming yourself or harming someone else. So you can't, just because someone has autism, you cannot Baker Act them. But if they have autism and they are acting in a manner that is a danger to themselves or a danger to others, then yes, they can be Baker Acted.
Thank you. This is so interesting and people are so engaged. There's one more question, then we'll move on.
Sure. No, I like it.
Everyone's been engaged today on this Friday. This audience member asked, are the police trained to handle mental illness?
That's an excellent question. And I'm going to say that's going to depend on the jurisdiction. It's going to depend on the department. But I think more and more now, especially the big departments like Fort Lauderdale PD, West Palm Beach Sheriff's Office and all of that, I believe more and more of them are training their officers to handle mental illness. And, especially now, again, because we have this culture where people are saying, the police need to be a little bit more, less aggressive, I guess is the right term. So I think they are doing more and more training. Sometimes though, and again, I've seen this happen where people are Baker acted because the police officer doesn't really know what to do, and so they Baker act the person. And it's probably, in an abundance of cautions because the person is acting out and is threatening or dangerous to themselves or others, and so they don't know what to do, and so they Baker act them.
Okay, so that probably answers the next question, which was, is there a requirement to de-escalate the person prior to Baker acting? And that probably varies widely between jurisdictions and police officers.
Yes, absolutely. I agree with that. I believe that varies completely between the different jurisdictions, the different police departments, and also, what's going on. When I hear words like this de-escalation, I have to say to myself, it depends on what's going on. If someone is out there, holding a knife or threatening, like the young lady with the shears where she's trying to chase the neighbor to stab the neighbor, I'm not sure de-escalation at that point is going to work. I think they're going to have to, you know, take her into custody, which they did, and they Baker Acted her. And so I don't think they even attempted de-escalation. So I guess it depends on the situation.
All right, well, thank you. And we'll get to some more questions a little bit later.
No, I'm glad that we are getting questions. That's good because it's very engaging and it's more of a discussion that way. All right, so, oops, did I go back? No, I'm going the wrong way. Hold on one second. All right, so we talked about who can invoke the statute. So now we're going to move into how long can a person be held involuntarily? They can only be held involuntarily for 72 hours. And oftentimes this is very disheartening to family members because they think once the person is Baker Acted, they'll be held and they'll get treatment and what have you. And that's not the case. Unfortunately, the statute is very geared towards the patient or the person who's being held because you're restricting someone's liberty. So a person who is Baker Acted can only be held for 72 hours. What happens then if the person is not stabilized after 72 hours? A person can be released outright. If the doctor at the facility feels that, and usually it's the state hospital, if the doctor feels that the individual has been stabilized or that, you know, they weren't taking their medication, for example, we see that very commonly. People stop taking their medication and they're on these psychotropic drugs, these mind-altering drugs, and they just suddenly stop taking them, or they start mixing them with alcohol and that kind of stuff. So in that situation, if the person then is given the medication and they're taking the medication and they're stabilized, they can be released outright. They can also be referred to outpatient treatment within 72 hours of involuntary commitment to a Baker Act receiving facility. And again, they have to agree to it. This is the other sort of just unfortunate thing, is that the person has to agree to it. If the person who's Baker Acted is not discharged within 72 hours, then the facility can ask for the person's consent to continue their commitment. And sometimes people will know, especially if they've stopped taking medication and they now start they've now been given their medication and they start to feel the difference, they may agree that they should stay there for a longer period. But it has to be voluntary. And they could get up and they could leave at any time. Or an administrator, if they can't stabilize the person, an administrator can file a petition through the circuit court for involuntary placement. The petition for involuntary placement must be filed with a court of competent jurisdiction. So, you know, you wouldn't file, a person who lives in Miami, you wouldn't file that petition in West Palm Beach, right? You would file it where venue is proper, just all the same legal stuff that we do for every other lawsuit. The court has to hold a hearing within 5 days of the involuntary placement. And that's a strict guideline. There have to be cause as to why they've gone over the 5th day. If the court finds that a person meets the criteria for continued involuntary commitment, then the court can commit that person to a mental health facility for up to 6 months. And again, I want to just stop here for a little bit because this is an area where there's a lot of difficulty. I mean, courts don't typically like to commit people. And so you have to show with specificity, and you meaning the facility has to show with specificity why this person has not been stabilized, cannot be stabilized, is a continued danger to themselves, a continued danger to others. It can't be just, oh, you know, this person is acting out still, or we don't think this person's stabilized in a sort of general form. It has to be specific as to what's going on and why this person must then be held. And then a court can determine that the person be committed to a mental health facility for up to 6 months. And I see that there are some questions, Christy, so I'm going to stop.
Okay, we do have a couple more questions that came in. The first one is someone who said they had a client not call a Baker Act for a family member because she thought it was public information and would follow them in job hunting.
It is public information. It's in the clerk's file. It's sealed kind of like juvenile cases and probate cases. From that perspective, you can't just pull it up. But if you were to go to the courthouse, you'd be able to get that record. You'd be able. It is public record, and that's kind of one of the other things that prohibits people from calling on their family members, because they don't want them to be affected by this later on.
Mhm. All right, and we also had someone who said they have a client who is a minor and suffers from autism and other disabilities. He has been Baker Acted several times in the past and was recently Baker Acted again. The mother told the facility that she does not feel safe with him in the house and does not want to take him home with her. And the facility told the mother they would call DCF. So now the child is back at home with the mother, but she is in fear living with him. He is currently on a waiting list for residential living facilities, but no one knows when he'll be admitted. What are her options? And I know you'll get to that further along about the tragic lack of options in Florida.
Let's deal with that right now, because there are a tragic loss of options. There are not many options that she can do. Without getting too much into the DCF, I've heard DCF say that a lot of times, and again, when I represent a child in juvenile, not necessarily a mental health child, but a child with a mental illness, but someone who's in juvenile for criminal issues, or battery on the parent, for example, and the parents like, I don't want them back. I had a situation where the young man was hitting his younger sister, who was about 9, and he was 16, I think. So the facility says, well, we'll call DCF. But the truth of the matter is, if you call DCF, DCF is going to pick up that child, and DCF is going to put them in a facility until the courts can handle it. So that's a threat that a lot of facilities do. I don't think it's appropriate, but they do it all the time. The lack of options for someone with a mental illness is, Christy and I were talking about this earlier, it is just extremely sad. There are no options. You have some outpatient facilities, but they don't, they're not allowed to restrain or keep the person there if the person chooses to leave. That's the same with even inpatient facilities. They, without a court order, they can't have that person, they can't restrain that person, they can't prohibit that person from leaving. So what often ends up happening is you go from Baker Act to prison, Baker Act to prison. There's sort of nothing in between. And it's one of the sad things about Florida. It's been this way for the last 20, 30 years, and I have not seen any improvement as far as facilities that are lockdown facilities, other than the state hospital, that are lockdown facilities where a person cannot leave against their will. Now, I'm going to talk a little bit when I talk about some of the powers of the court, but it's very limited, extremely limited. Was there another question, Christy?
And one more, is the Baker Act procedure the same for adults and children?
Yes.
That's it for now. Thank you.
Okay, so if a person has a pending criminal charge, and this is where we talk about the power of the courts. And before I go forward, Christy, how are we doing on time?
We are at 11:30, so we've got 30 minutes left, and if we have more questions at the end, people can stay if they're able to.
Okay, I don't want to run over. Okay, all right, so if the person has a pending criminal charge, the prosecutor or the court can require involuntary commitment as a part of a plea. And sometimes, the family will ask for this. They'll say, listen, this person is dangerous. I am worried. I don't think they should, come back home without getting some kind of treatment, especially those who have never been given any kind of medication or any kind of evaluation or what have you. If that we can, as attorneys, as defense attorneys, we sometimes work out that as part of a plea agreement, with a prosecutor, which is awesome. If you get the right prosecutor, and this is kind of another pet peeve of mine, that they have mental health prosecutors. For example, in both Broward and Palm Beach, there are specific mental health courts, and they are awesome. Those mental health courts are more for their therapeutic type of courts versus punishment court. But sometimes the person may not be eligible for whatever reason to go to mental health court. So for example, robbery with a firearm, even if you have a mental illness, you're not permitted to go to mental health court because it involves a firearm. So in a regular division, and a defense attorney who's on top of the game and knows that, there are things that the prosecutor can do. The prosecutors have a lot of power, not to digress, but they have a tremendous amount of power. People think the judge have the power, and they do. But the prosecutor, as far as what happens to that person, has tremendous power. So oftentimes I'll talk to the state and I'll say, listen, my guy has a history of mental illness, and I get all of that. I do a full-fledged on hearing, like a trial, a little mini trial. And I bring in all of the person's mental health records. I hire mental health experts to come in and testify. I use doctors that I'm familiar with, that I know. For example, Dr. Michael Brannon, Dr. Lori Butts, they know how they've worked in criminal mental health field for a long time, and they know exactly what is needed to get the point across to the judge. So I'll hire a mental health expert to come in and testify. And if the family can't afford to pay for a mental health expert, there's monies in the state through Justice Administrative Commission where I get them approved for that and have the doctor be able to testify. I bring in family members who can talk about that person's behavior when they're taking medication, for example, versus when they're not taking medication. And I put on, as I said, a full-blown hearing. And at the end, either I'll do that for the purposes of the prosecution, where I just get all the reports together and give it to them, or we put on a hearing before the judge if the prosecutor is not agreeing to it. But a lot of times the prosecutor will say, okay, I agree, and what do you want? And I'll say, well, the family wants him to go to, or her to go to, a facility for 6 months to receive treatment, evaluation, and to continue whatever the recommended treatment is by the mental health professionals. And the prosecutor will put that in their plea agreement as part of a probation plea. And oftentimes the clients adhere to it. Now, you do have some clients who they leave the facility, or they do something at the facility and they violate their probation. But as a general rule, I found it to be very effective to help our clients to get some help, because otherwise, they're being sent to the Department of Corrections, and the Department of Corrections being used as a mental health facility when it's actually a prison intended for punishment. So the court or the prosecutor, I like to work with the prosecutors because then I know exactly what I'm getting. The court can go either way. All right, so let's change now gears and go into the sister statute, if you will, which is called the Marchman Act. And this is Florida Statute 397. And before I move on, any questions about the Baker Act?
We did have a couple come through. Someone was asking, when you mentioned that facilities can't keep people against their will, is that the same for adults and minors?
That's the same for adults and minors. Remember, they're only can be kept for 72 hours unless there's a court order, which grants up to 6 months. But other than that, they cannot be kept against their will. Now, I would say with minors, parents may have the right to say, no, the child has to stay there. But again, even that has to really be done through a court order. Because remember, you're taking away someone's liberty. This is like putting someone in jail. So you're taking away their liberty. So all of the due process rights that we're entitled to as Americans do not go away when you have a mental illness. You have to be, it has to prove that your due process rights are not being violated. Because think about this for a minute. Let's just say, and I've seen this happen, this is why I'm going to use this example. Let's say you have a mom who dies, and a mom leaves behind some money, you know, 100 grand, not a ton of money, but enough to make people sit up and take notice, right? And dad's like, I don't want child to get this money. And I don't want this to go into a guardianship for a child. So what I'm going to do, I'm going to say that the child is, you know, acting out and doing something that is dangerous and in danger of harming him or herself or others, and have that child Baker acted and then committed to a facility indefinitely. Let's just say that that could happen. You see how people could really abuse that kind of power. And so the courts want to make sure that when we're putting someone in a mental health facility, that they should be there, that they rightfully should be there. And this isn't some kind of, you know, or the child has autism and you don't want to deal with that. So you say, oh, well, I think they should be put into a facility. So it's really to prevent that kind of abuse and to make sure who is being committed to these facilities should rightfully be there. Anybody else, Christy?
One more question, a policy question. How do we petition the state to demand some sort of middle ground facility rather than sending everyone to prison?
I think it's the same like we do with all other laws. We have to find, and you know, Florida Legal Services and other organizations who are policy type agencies, we have to find people who are willing to sponsor bills. We have to find legislatures who are willing to sponsor bills and get these bills into our legislative branch and try to help to and push to get them passed. It really is a huge statewide problem. It's not just one particular area. And I would probably venture to say it's not even just the state of Florida. It's probably more of a national dilemma that we have. But I think just like with everything else, we really have to start pushing our legislators and saying, listen, we need these types of remedies to be passed to help people who are mentally ill. Half the people that you see who are homeless, and I would venture to say, I'm using the number half. I don't have, again, no statistical data, but I would say half the people that are sitting on the street that you see who are homeless have some form of mental illness. And they were prior veterans or they were business people. Not everybody that we see on the street is there because they're lazy and don't want to work. A lot of individuals who we see out there are suffering from a mental illness, and you know, they just haven't gotten the help that they need.
All right, so that's everyone's call to action for this Friday. And that's it for questions for now.
All right, so let's move then into the Marchman Act. As I said, that's governed by Florida Statute 397. The Marchman Act is different than the Baker Act in that it provides for involuntary or voluntary assessment and stabilization of a person who is allegedly abusing substance like drugs or alcohol, and provides for treatment of substance abuse. So in effect, the Marchman Act is strictly a drug and alcohol abuse statute. It has nothing to do with a mental illness, and is very different, very distinct from the Baker Act in that respect. So who can then file the Marchman Act? What is the criteria for it? The petitioner or the person filing has to file a petition and have direct evidence of the person's inability to manage his or her substance abuse, or that the person has lost the power of self-control with respect to substance abuse. So it can't be just that the person is using drugs. The person who's filing, or the petitioner who's filing, has to show that the person cannot manage his or her own substance abuse and has lost the power of self-control. You also have to show that the person has inflicted or has threatened or attempted to inflict harm on himself or another. So that's similar to the Baker Act. You also have to show that the person's in need of substance abuse services, and by reason of his substance or her substance abuse impairment, his or her judgment has been so impaired that the person's incapable of making decisions, rational decisions for themselves. So it's not just that they have a drug problem. It's not just that they're using drugs or alcohol, but they've lost control, and they've lost so much control that they can't make any kind of rational decision about their care as far as their medical care, and they have inflicted or threatened to inflict harm upon themselves or others. So the Marchman Act procedure, here it's not just calling the police or going to someone's doctor or trying to get them that way. You have to file a formal petition for involuntary treatment in the county where the person resides. The Marchman Act requires that the petitioner be a spouse, a blood relative, or a group of 3 individuals with knowledge of the individual's substance abuse. The petitioner must believe and have direct information that the user does not have the power of self-control and is likely to harm themselves or others. And you have to provide evidence that the user cannot make rational decisions for themselves. All right, so after you've filed your petition, then what happens? So the court will set a hearing within 10 days after the petition's filed. And again, as we said earlier with the Baker Act, these dates are hard and fast. The 12th day is too late. So you have to file it with the court has to have a hearing within 10 days or show good cause that they couldn't hold the hearing for whatever reason. The person who filed the Marchman Act, the petitioner, is mailed information regarding the hearing, and then the respondent is served with the documents, with the papers by law enforcement. This is one of those where, again, you cannot use a process server to serve the person that you're trying to Marchman Act. It has to be served by law enforcement. During the hearing, the court will evaluate the need for the involuntary assessment, as well as any professional addiction treatment to determine a potential resolution. Okay, so under the Marchman Act, a person can be held voluntarily for 5 days. So that's a little longer than the Baker Act. But in the meantime, the petition is before the court, the person's being held for the 5 days, and then the court has to have the hearing within 10 days. So what happens then if a person who's Marchman acted is not stabilized after the 5 days? Here the difference is the court can order the person to involuntary inpatient treatment for up to 60 days. And that's substantially different than the Baker Act, where the court can do it for 6 months. Here it's up to 60 days. Okay. So with the, technical difficulties, here we go. So with the Marchman Act as well, the family can come together, and if they can find which is substantially different than the Baker Act, if they can find a facility that provides substance abuse treatment and alcohol treatment that is inpatient, that's another thing that you can use if the person is charged in a criminal setting. This is another area where the prosecutor, having a good relationship with the prosecutor, is important, because if your person suffers from substance abuse and or alcohol abuse, you can, instead of sending them to jail or instead of sending them to prison, you can work out a deal with the prosecutor that says, listen, let's put them, let's commit them to a facility, an inpatient facility. Again, after 60 days, that person could get up and leave. But usually what I find with the Marchman Act, where people are committed involuntarily for that 60 days, once their system starts to be cleaned out of the alcohol and the drugs, oftentimes those people will stay. Whereas you see the converse in the Baker Act, where a lot of times people are like, I feel great, I'm taking my medication, I'm out of here. So it's a lot more difficult sometimes to keep someone in an inpatient facility in a Baker Act, whereas with a Marchman Act, once they start becoming clean, oftentimes, at least just my own experience, the individuals will want to stay. So that's the Baker Act and the Marchman Act statutes and how they operate. And again, I would open up the floor for questions.
Thank you so much for all that great information. We did have a question come in. You said during the Marchman Act presentation that it has to be requested by a blood relative. So the question was, you couldn't petition for an adopted child or a sibling if they're both adopted but not related by blood?
I would say you could. That situation has not come up for me personally, but I would say you could, because under the adoption laws, right, once that child is adopted, they have all the same rights, right, as if they were your blood child. So if you die tomorrow, they can take from your estate. If you abandon them, you can be charged with neglect and abandonment. If you choose to change their school, you're allowed to do that. So I would say that the adoption would be, and I would argue, if that was ever raised, I would argue that the adoption laws are pretty clear that you become the child of that person who adopted you, and so the same rights there would apply. I think the statute says blood relative, meaning as opposed to, you know, your coworker or your friend down the street. Again, they wanted someone who's close enough to you, who knows about your drug addiction or your substance abuse addiction. Also, keep in mind that the statute does allow 3 unrelated people, but it has to be 3, who can agree that you need this involuntary commitment.
Okay, that makes sense. So last chance to get your questions in. As we wait for questions to come in, I did want to let everyone know that the Florida Bar did approve this webinar for CLE credit. It's approved for 1 general credit or 1 mental illness credit. The CLE number is 2005 500N as in Nancy. Again, that's 2005 500N as in Nancy, and I'll also put that in the chat box. And I see we had a question come in. As a non-lawyer, how can I help facilitate the process of helping the legislature provide more local and state changes?
Well, one of the things you can do is start writing to your legislatures. It's the same as any other issue that would come up. You know, I don't know if you guys, the last couple of the last election cycle, not this one just gone, but the one before that, where the Amendment 4 came on the ballot. When an Amendment 4 basically is to allow felons who have served their time to now be able to vote, right? That didn't just get there. That came from a process of starting out, finding someone to sponsor a bill. If you know a local local elected official, if you know somebody like that, doesn't have to be, you know, somebody who's currently in Tallahassee, but somebody who's at your local level, who you can talk to, who might be able to connect you to someone else who can write a bill. Also, reaching out to Florida Legal Services. Florida Legal Services does a lot of impact litigation. And correct me, Christy, do you guys don't get involved so much in the policy? It's more the impact litigation, correct?
Right, and there are certain people on the line who work for LSC restricted agencies, so they're not allowed to lobby.
Okay.
That restriction too, but not everyone has those restrictions.
Right, right. And I think Christie's better positioned to answer who can and cannot do those things. I know as a private attorney, I can, but I'm also on the board of the Florida Association of Criminal Defense Lawyers, so I have to be careful because they're not allowed to lobby under certain conditions. And so, you know, or FLS, because I'm on their board, I have to be careful. So I would definitely speak to someone who is much more savvy about how to get bills in front of the legislature and work there. But the fact that you're even asking that question is awesome, and I commend you. Thank you so much. talk to some of your local legislatures, and they will tell you how to get things happening. These bills don't just get there. People like you who are asking these questions get it started grassroots and then move it on up the line.
All right, and we had another question come in. Have you had cases that you have seen the person become healthy and able to live a healthy life?
Oh, absolutely. Absolutely. Listen, mental illness, or at least from my perspective, I see mental illness no different than diabetes, high blood pressure, all these other illnesses that people are living with every day. And I would love for us to get to the point where we move from mental illness as this taboo to recognizing that it's just like any other illness in the sense of it needs to be monitored, it needs to be treated, it needs to be nurtured, just like any other illness, right? So I see clients, as a matter of fact, I have a client who is a single mom. Her child had been removed by the department. After a couple of years, she was able to work and do everything, her case plan, take her medication. Her medication is part of her case plan. And now her child is back with her. She's healthy, she's doing well, she's productive. It can happen, and it happens more often than we think. The sad thing is, often when I see these clients, I'm seeing them in a criminal setting where they happen to have mental illness. And so it's unfortunate because the clients I'm seeing are going to prison or going to jail or what have you because, it's both. They've committed a crime and they also have a mental health illness. And unfortunately, also too, a little bit of digression, in the criminal arena too, prosecutors are suspect when you use the term that someone has a mental illness, and they're suspect when you say someone has a mental disability. They don't necessarily believe it. So you have to really, as the criminal defense attorney, prove up that portion of your case. And what I find is when I'm doing that, a lot of these individuals have a long history of mental illness. And it's because no one's really addressed that, why they keep committing the same crime over and over and over again. Once that's addressed, you tend to see people doing much, much better. And I see that when I worked in mental health court, when I was at regional council, I saw that a lot where people started off, really in a bad shape. And at the end of the time being in mental health court, because it is a therapeutic court, they are able to function and have a normal life. And a lot of it has to do with medication and taking their medication and family support and all the things that we all need.
Thank you for doing all this difficult work. It's good to hear there are some positive outcomes, but I agree with you. This touches every family, just like heart disease and diabetes. Everyone knows someone who has a mental illness and struggles with it. Someone asked, how can we volunteer to help? So I wonder if those mental health courts you were talking about, do they have community mentors or any other way to get
Yes,
involved?
they do. Yes, they do. If you are in Broward County, and I don't know where everybody is, and I can only speak of Broward and Palm Beach because obviously that's where I practice. But for example, in Broward County, the mental health court, they have advocates. There's all different organizations. Henderson Clinic in Broward, for example, they provide referrals to different facilities. There's a lot that can be done. And as a matter of fact, reaching out to the mental health court or the mental health director in your jurisdiction is probably a good place to start because they're going to be able to direct you to the local social services that you can help out with too. In Broward, for example, there's a court called Community Court. It's headed by Judge Florence Barner, who's an amazing young woman. She's relatively new to the bench, a couple of years on the bench, but she started this community court, and part of community court is looking at people who have a mental health disability and trying to find social services to help them to to sort of navigate through the legal system. So that's really amazing. And I mean, literally, in Broward and Palm Beach County, these courts now are really just looking at social services and helping people with social services more so than they're looking at punishment.
That's good to hear. I put in the chat box that people can check with their local mental health court to see if they have volunteer positions available. And I also wanted to recommend something that I believe is in every county, the National Alliance on Mental Illness. They have a lot
Right.
of community programming for family members or people with mental illness themselves. So it's a good source of support. But thank you so much for all this fascinating information. I know I learned a lot, and thank you to the audience for being so engaged with this. And I
Yeah.
really took time out to do this. It's much needed. Hope everyone has a great weekend, and the recording and materials will go out into your email tomorrow.
Thank you so much, Christy. Oh, someone raised their hand. Jeff, I think.
I don't see any last minute questions. I have a lot of thank yous. This was a great seminar. So thank you so much for doing this again.
Oh, thank you guys for having me. I really enjoyed it. As I said, I feel like I'm home with my legal aid plan. So,
Have you back.
all right, thank you. Thanks, Christy, and thanks to FLS. Take
Bye.
care.